So you'll remember I sent y'all the jury charges. I did want to have, I don't plan to have a full entire charge conference right now. But given that I expect that the state will probably be wrapping up its case first thing tomorrow, and that we either will or won't hear, depending on what the defense decides to do, I think it makes sense for us to at least have a first pass. Have the parties had a chance to look at the jury charges that I sent, and any specific matters y'all want to address in terms of concerns you have. Yes, sir, Mr. Samuel.
Yes, I've looked at them.
Okay.
You want to go specific?
Any from the state? Who's going to be handling that for the state? Like, I'm sure all of you, but which one of you is going to talk about it?
I haven't looked at them yet, Your Honor.
Okay. Well, I tell you what, let me make it easier so you're not.
A couple typos.
That's why I asked you to look at them. So let me put them on the screen, and I think that will help, because it will also let you understand how they will be displayed to the jury when I do the charge. So anyway, the second charge is just a general pattern charge. It's not a pattern charge. It's just a general charge of, hey, the law is what I say it is and not what the lawyers say it is. And then beyond that, other than typographical errors, all of these are pattern charges. The only issue is to this evidence in this case, is such that you shouldn't be given or need to be tailored further.
I can give you a list of my
Sure.
issues. 131.42, witness supported. I'm not sure we had that.
Yeah, so again, I exercised no editorial control over this. I simply put on here what you guys had listed. So not only have we not had that, but generally speaking, attacking a witness and under 131.41 is a very specific process that sometimes may or may not have happened either. I agree with you. We certainly have not had any witness supported. I'm not even sure we've had witness attacked, except perhaps by, that one needs to be tailored, because perhaps by prior convictions.
Yeah, and then
Hang on, what are your thoughts in terms of witness supported? Ms. Hilton, the conversation we were just having.
Yes, Your Honor, we agree.
I haven't heard anyone be rehabilitated in that manner.
Correct. We will withdraw 131.
Okay, and to be honest, I don't know that anybody actually asked for that one. It's one of those, they go together, and if we have witness attacked in that particular way, then I'm going to keep witness supported in that way unless somebody agrees it shouldn't be. Mr. Samuel?
I made a note of 131.80 in case anybody was wondering what we were referring to. I was referring to the immunity of Norma Patton.
Right, you made that note in, did you have a chance to file? I know you gave them to me, and at the time you gave it to me, you said you had not yet filed the jury charge request.
I served it. No, I didn't. I don't know how to file.
Well, somebody in your office certainly does, Mr. Samuel, so.
Yes, someone could do it, yes.
Okay.
But everybody's got it. You know, what to do about 404B and all the 1.3410, I'm perplexed. I'm beginning to think you're just not going to give any 404B instruction at all because there was no similar transaction evidence in this case.
That is, I think you're beginning to suspect correctly.
Yeah.
As I was looking at it, I had always wondered, because I'd not heard what I would clearly categorize as 404B. I understand your objection and your belief that that these prior alleged, the testimony that the state has offered about prior incidents that they would characterize as abusive in support of Dr. James or Ms. James's testimony. I believe, as I said at sidebar and then said again when I declined to give a limiting instruction, I believe that those are intrinsic, and that intrinsic evidence is allowable. The jury can consider it for any purpose, and so there's no basis for a limiting instruction.
Right. To be candid, I can't even figure out what the limiting instruction would be, which is kind of my whole issue, is what was it? Unless we accept your position that it's just all part of the crime, I'm not sure what the 404B instruction would even be, which is why I thought the evidence should be excluded. But we know where we've been on that.
Sure, yeah, and I think you have, I think I have, after I had that discussion with y'all at sidebar, I think I actually went in and deleted those limiting instructions and the associated other crimes, wrongs, and acts
I
instructions.
don't want to waive my issues, but I certainly
course.
understand that they're not appropriate if in fact they weren't admitted as similar transactions. Okay.
Yes, sir.
I think prior difficulties, 13420 still stays in now.
Any objection?
No objection to 13420.
It needs some editing, but
Well, yeah, I mean, if there are parentheticals still in there, that means I haven't tailored them yet, but I'm not going to waste time tailoring stuff if everybody says, no, we don't need it, so.
Right.
Can we go back to 13180, the immunity or leniency?
Yes.
Your Honor, the state would object to that being given. While Ms. Patton did discuss the immunity she received, that was as related to her trial with Mr.
Patton?
Mr. Carl Patton. Is not anything doing with this current case. She hasn't been given immunity. She hasn't been charged with anything in this particular case or matter before this jury. There's no pending prosecution before this jury. There's no negotiated pleas. She wasn't a co-defendant in this case, so there's no grants of immunity or leniency or similar matters as it relates to this case. So we would object to 13180.
Mr. Samuel?
Usually I do charges sitting down, but I'll stand up.
That's fine. You're not bothering me.
Once you're given immunity, you're given immunity. It carries forward, all the federal cases and all of which are, the names of which are escape me now, but the New York case. Anyways, the U.S. Supreme Court said once you're granted immunity, it's good for life on that grant of immunity. So theoretically, which is all that really matters for this, she could still be prosecuted, and because the statute of limitations hasn't run, because it never does in a murder case, she could be prosecuted in theory in whatever it is, Henry County, Fayette County, wherever. And so having testified here, because she was immunized, she doesn't have to worry about that. If she hadn't been immunized, and she got on the stand here today, yesterday, whatever day it was, and said, yes, I participated in the murder of some of the people my husband killed, she could be prosecuted for it. But she can't because she's immunized.
So my concern is not quite, I think right now I sort of agree with Mr. Samuel, but not for the reason that he's outlining. It's more that my understanding of the law around it and the pattern charge certainly is that it's not specific, right? It doesn't say they were granted immunity in this case. And so if it's intended to be, because the factors we take into consideration when we're assessing the credibility of a witness are pretty broad. These are just examples that we give a jury in terms of things they can consider. If the state wants me to think about not giving that charge based on Mr. Samuel's request that I give it, I would say see if there's case law that talks about it being specifically designed for immunity in a case, as you outlined correctly, Ms. Hilton, that Ms. Patton was never in any jeopardy associated with this case, and I'll consider that tomorrow.
The
Okay.
case is Murphy versus Waterfront Commission of New York Harbor, 378 U.S. 52.
378 U.S. 52.
Yeah, and there's a long discussion of it in a Supreme Court case decided 6 weeks ago, Coleman versus the state.
K or C?
With a C, S25 A0191. Different circumstances, but it talks about how broad immunity really is. Once you've been given it, you're protected for life in every court of that testimony.
Okay. And as I said, that may go directly to my point that this pattern charge is not specific about this case. It's just about immunity generally, and if that's the case, then I will give it based on your request, but I would like some more information about that topic. So I'll take a look at this case and hear from the state tomorrow on that issue.
Your Honor, before you go, I'd just like to cite a case from Georgia, Lee versus State, 281 GA 776. And I believe the proposition is that the general credibility instruction adequately covers that.
Adequately covers the other immunity?
The other instruction.
Okay.
I need to drill down on it exactly,
Sure.
but that's what it's saying in the notes on the jury charges.
Okay.
So I'm going to look at it as well. I just wanted to give that to the court.
Thank you. I appreciate that, Mr. Wilson. Okay. Anything else, Mr. Samuel?
Yeah, a few more, but they're not big. 13430, it really just needs to get rid of all the parentheses for the defendant. No felonies of Mr. Wolfenbarger's work, but all the witnesses.
Yeah, that's why I haven't tailored it, because
Yeah.
I
At first I crossed it out, but then I realized, wait a second.
Yeah, there's lots of witnesses we've heard felony convictions about. And so if evidence comes in about felony convictions of the defendant, right, then I'm not saying it has, I'm saying if it does, then I would tailor it to be, you've heard evidence about both the defendant and a witness's criminal history. But if it's just witnesses, I'll say that.
Right. I'm a little in doubt about 13510 identification. The first page of it, I think, is fine. You got to prove that the defendant did it. That have identified him as being, but this is
all about whether you can trust eyewitness identification, et cetera.
which we really didn't. I mean, it's not an issue in this case. We don't have any eyewitnesses identifying anything. So I just thought we should get rid of that and 13511. Those two pages, but leave the first one, because that just says someone's got to identify the defendant as the perpetrator. It doesn't necessarily have to be in court, but
I believe we may agree, but if I could just have a moment
Sure,
tonight to
that's fine.
get it back.
Yeah,
We may be in agreement about that.
Okay, let me know. Like I said, I think to Mr. Samuel's point that second part, the some but not all of the factors, if you read those factors, they really do go to a stranger's identification based on eyewitness observation, and that's not really what this case is about. I'm not sure I necessarily agree with your assessment of 13511, that would be more directly here in terms of the state's obligation to identify a defendant, but we'll go, I'll let the state have a chance to look at that and consider it and tell me
I
tomorrow.
crossed out my crossing out.
Okay,
That was in, still in.
okay. Anything else, Mr. Samuel?
Got 2, 3 more.
Sure.
I'm not sure about the motive instruction. I think they have to have evidence introduced of the motive. I know motive is in the malice murder instruction already. That motive is not an element, but, may help you decide. But I don't feel strongly. I know it's a pattern instruction. I just don't know that there's evidence of motive that's been introduced exactly. And it seems to.
Except that the pattern says they don't have to prove motive to prove murder, and it also says any evidence of motive. If you want to argue there isn't any evidence of motive that's been offered, you can argue that, and they'll say, but yes, there has been. It doesn't matter. As I understand it, that one is written broadly enough that both sides can argue, here's our evidence of motive, even though we don't have to give it to you. And you can argue there isn't any.
There was I got a typo in causation in felony murder 21030.
Yes, sir.
But 22023.1, which was ours, I'm not quite sure what to do about that.
I'm sorry, what is the typo?
2.20.23.1.
No, I'm sorry. What was the typo in the causation charge?
It says felony murder if you believe that they instead of he.
Thank you.
Yep.
2.20.23.1. I just don't know how we're going to address this, but we need to probably think about it. Everybody needs to think about how we're going to talk about the aggravated assault that makes it aggravated.
Yeah, I full disclosure, when I was drafting these charges, realized that I've tried a number of felony murder cases. I've actually not tried a felony murder case before this one where the underlying felony wasn't also charged. I don't know, as my understanding is, it's not required to be, but I've just not had one where it wasn't also charged.
Well, they actually didn't even request ag assault in their pattern.
I understand.
Which Joel and I spent a lot of time thinking about why they didn't do that. But at any rate, we did. But now the question is, how do you do it?
Well, I think we all obviously need to have a more detailed conversation about it tomorrow after everybody's had a chance to look at it. But the aggravated assault charge is I think is less confusing. The issue is deadly or offensive. I don't think that I can meaningfully charge the jury on felony murder if I don't tell them, but the felony is based on an underlying alleged aggravated assault. So I think I have to tell the jury, as felony murder says, the underlying felony that's alleged is whatever, and I will define it for you shortly. So I have to tell them what aggravated assault means, but that typically requires the court to explain what type of weapon did it, because that's one of the elements, is that it was, you assaulted another person with an offensive weapon, and then you have to explain what was offensive about it.
Murder, felony murder.
Just to anticipate what we may be talking about tomorrow, it can't be strangulation because that's a separate crime, which is not alleged.
Is the aggravated assault
It's only offensive weapon, not.
charged as an offensive weapon in the indictment?
It's,
Okay.
you want the indictment?
Okay, anything else?
Nothing, that's all I had on my list.
Okay. I'll just note, in case y'all didn't, it sounds like you would have looked at it, but I do, another one that is non-pattern that I typically include. I cannot believe there's not a pattern on multi-count indictments. But this is the one that a lot of us use, and so I include it. You'll also probably note that my charge is sort of in the order of, this is how you consider evidence, and this is, what's been presented to you and how you should think about it. Here are the elements of the crime that you're supposed to be determining if you believe occurred, and then here's how you deliberate. That's sort of the way it's broken up, and so you'll note it's not in number order, but that's sort of how I present it. And also, I sent y'all a verdict form the other day. It's pretty straightforward. It just says we find the defendant guilty or not guilty on count 1, guilty or not guilty on count 2. Any objections to that verdict form?
None from the state, from what I've heard.
Nothing from the defense.
Okay. So I think it sounds like what I'll do is I will tailor some of the ones that it seems like we're in agreement are going to stay in based on the evidence as it currently exists. Obviously, they can be tailored again, depending on, I sometimes will tailor the defendant's choice not to testify, depending on whether he testifies or not. Although I think the pattern is written generically enough that it can stay in either way. And then obviously, depending on any additional evidence that comes in regarding criminal history, I can tailor those. Beyond that, what I'll do is wait until tomorrow, specifically so we can talk about the aggravated assault and offensive weapon charge, what we're going to do with that, and then the other ones, the other few that we've discussed.
Can you ask
The
about
immunity charge, yes, sir.
tomorrow- I'm sorry. Can you ask us about tomorrow's schedule? It's 10:30 because you have something else we need to clean up? Do you have another calendar?
Yes, I have the presiding bond calendar tomorrow morning.
So we need to clear out.
Yes, sir.
Okay.
I'm sorry.
We'll put everything in the back. And assuming our case takes a couple hours, I don't know if they have rebuttals. Do you envision going into closing argument tomorrow, or waiting until Friday morning for that?
If what were to happen is that the state were to stand up and rest in the morning, and then you put on a case that is relatively straightforward and short, even assuming rebuttal, the state, we probably would be done still in the afternoon. I'm saying pushing 3 o'clock is my guess. At which point I'd rather get a final on the charge and start fresh on Friday morning with, we all agree that we've got the charge final. And so you guys get ready to do your closing, and then I think that time would be better spent tomorrow afternoon. So no, that's a very long way of answering your question, Mr. Samuel. No, I do not expect to go into closing arguments tomorrow afternoon. Anything else?
No, you're right, nothing from the state.
May I have just a second, please?
Yes, sir.